Hello and welcome to Take from Caesar. Here's yet again another instructional video. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it. Yes, the government will if the government can't handle you with the law, the government will handle you without the law. That's a really an underlying principle for the purposes of this presentation. The overlying reason for this presentation is to acquaint you with the fact that, yet again, many people are derelict, incompetent, naive, and ineligible for legal analysis, with regards to legal analysis. When it comes to legal analysis, there are people you simply can't afford to listen to. And it's one thing to sit out here and say, well, gosh, these people really blew it. And who am I? That's why I'm going to leave it to the Supreme Court and the Second Circuit Court of Appeals to acquaint you with the fact that a lot of people got this one wrong. People with credentials even. And a whole bunch of other well-intentioned but incompetent bullhorns or trombones. They got a great big voice, they got websites, they got radio shows, and they are wrong. The title of today's video told you that it's about the NDAA, the National Defense Authorizations Act. And everybody said, oh my God, we're going to the FEMA camp and they're going to burn us in an oven because the executive branch just got the authority through this National Defense Authorizations Act to detain Americans without habeas corpus indefinitely till the end of hostilities in this war on terror, when we in fact know the hostilities will never end. The war on terror is justification in the eyes of the government to declare war all over the planet. Wherever anybody contradicts the U.S. government, they're going to get a brand placed on them, a terrorist group, a terrorist organization. They'll be put on the Department of Defense's terror watch list. They'll be put on, their members will be put on the no-fly lists, and the government will perpetually be at war all over the planet until the cartel that owns America owns every other country. And so when they can detain Americans till the end of hostilities, it's till the end of time. And we know the government would never do that for us. They'll find a way to just terminate us while they have us in custody. Well, I've proven, as I stated in my disclaimer, the law doesn't matter here. If they can't handle you with the law, they'll handle you without the law. So first and foremost, the government doesn't need a law. There's plenty of innocent people in prison. You got Supreme Court decisions of the summer of 2015, and this video is July 4th, 2016. The Supreme Court ruled that criminal intent is an element of every criminal statute. Well, how does somebody that files, however wrong they might be, with well intentions, good intentions, they filed a Pete Hendrickson tax return. I'm talking about the anti-tax movement, my favorite whipping boy, Pete Hendrickson, who is the grand derelict of all derelicts regarding interpretation of tax law. And a bunch of people went to prison for filing his tax returns. Well, here they are. They're going on record. They put these tax returns right into their administrative records, signed under penalties of perjury, and the government says they believe they have a duty, and therefore they're criminally intentional. Well, how did they believe they had a duty to file tax returns the way the IRS says when they filed under penalties of perjury these contrary statements? They didn't have criminal intent. They really believed they were within the law and within their rights to do what they did. And they go to prison anyway. So the government will handle you without the law if it can't handle you with the law. And so they don't need the National Defense Authorizations Act. They'll find a reason, they'll pound on it, and after they get the indictment by misinstructing the grand jury, they'll threaten you with the indictment of your relatives, your associates, your dog, your real estate agent, everybody you ever heard of, to get you to plead guilty. To keep from having, or a superseding indictment. And so to avoid the superseding indictment and the destruction of your entire family under false indictment, a lot of people just plead guilty and do their time. And that's how they keep a lot of prison beds filled. So they don't need the National Defense Authorizations Act. They'll simply do it without it. That having been said, let's step up a layer and pretend that the government does need the law. We have Hedges versus Obama. Christopher Hedges right here. Daniel Ellsberg, you might have heard that name, a journalist of note, versus Obama and others in the U.S. government. The minds behind, I use that word loosely, the minds behind the National Defense Authorizations Act and its enforcement. And this is a case where the plaintiffs say we're activists, we are journalists, and we are anti-typical government conduct. They're not anti-government. They protest what government does. Not all of government behaves this way. I paint with a broad brush because I'm sick of it. But others that do not paint with a broad brush might say that, well, we just protest some conduct on the part of the government. And here we have the National Defense Authorizations Act that says anybody that is deemed a troublemaker, you can go to prison indefinitely without habeas corpus. That's the thrust of this lawsuit filed for a declaratory judgment, which is 28 U.S.C. 2201 and 28 U.S.C. 2202, other relief or injunctive relief. The plaintiffs asked U.S. District Court for the Southern District of New York to issue a restraining order against the enforcement of the NDAA. Please, we need the courts to step in and prevent the enforcement of this unconstitutional piece of legislation that authorizes the detention of Americans without habeas corpus. We need that relief in the form of an injunction. Please tell the federal government that because it's unconstitutional, they have no authority to enforce this act against us, the plaintiffs, because we are troublemakers. We expose government misconduct. We write about it. We protest it, and so we're going to be deemed troublemakers under this act, and we're all going to die in a FEMA camp. And District Court, and this is the opinion and order. This is it. Date filed May 16th of 2012. Now, when I had a radio show, look at this. There's an episode I devoted to this topic, so this is not new. As you can see, November 19th of 2014, I covered this in a radio show that I did, and you can find that episode at my TalkShoe archive page, talkshoe.com/tc/59615. Scroll through those shows for the November 19th, 2014 episode. Or you can go right to the audio for that episode by typing in this address, if you feel energetic. And the show's caption or subtitle was National Defense Authorizations Act, no big deal. pandaunite.org, no big deal. Education first, then activism. Don't be a fool. And I'm going to prove to you, I'm going to let the Second Circuit prove to you that all these people are way off the mark. All of them. Anybody that says the National Defense Authorizations Act has authorized the president to arrest troublemakers in the 50 states who are Americans and hold them indefinitely till the end of hostilities without habeas corpus. They all missed it by a million miles. And here we have the introduction by the court, District Judge Catherine B. Forrest. On December 31st, 2011, President Obama signed into law the National Defense Authorization Act. Plaintiffs, a group of writers and activists, brought a lawsuit on January 13, 2012, seeking preliminary and permanent injunctive relief with respect to one section, indeed, only one page, of that voluminous legislation, Section 1021. Remember that, Section 1021. Plaintiffs assert that Section 1021 is constitutionally infirm, violating both their free speech and associational rights guaranteed by the First Amendment, as well as due process rights guaranteed by the Fifth Amendment of the United States Constitution. On February 27, 2012, plaintiffs filed a motion for a temporary restraining order, which they subsequently converted to a motion for a preliminary injunction in a conference with the court, seeking to enjoin enforcement of Section 1021. In support of their motion, plaintiffs assert that 1021 already has impacted their associational and expressive activities, and would continue to impact them, and that 1021 is vague to such an extent that it provokes fear that certain of their associational and expressive activities could subject them to indefinite or prolonged military detention. Here they have two motives. One is that it has already impacted their activities, and two, that it is vague to such an extent. That's when you doubt your conclusion. You say in your mind, there's two ways they can go at this. They can use it to impact my activities, or it's worded in such a way so vague that we're having to guess as to whether or not it would impact our activities in a legal sense. There's a lot said right there in just this sentence. Two grounds that are not in harmony. First one, it has already impacted. That means we're worried and we're adjusting our activities to fit this law, and we're worried that it will impact our activities. It already has to an extent. We don't associate with one another as much as we did, or maybe altogether. We are out of association because we're afraid of going to prison. And number two, it's vague to such an extent. Well, that expresses a doubt in the original interpretation they had. We're positive that it'll put us in prison. And number two, it's so vague that we aren't sure it's going to put us in prison. There's a lot right there, right in this expression. As we go through this, when I look at I haven't looked at this in months and months. And it still says the same thing to me, just right on this review of it. I did not review these documents in preparation for this video. And when I read a paragraph like that, I know the void for vagueness doctrine is a totally different challenge than an affirmative challenge saying this is unconstitutional because it's restricting our free speech. The second one is, in case we're wrong, we should challenge on void for vagueness too. Sure, in case we're wrong. Why, if you thought you might be wrong, see how that just springs right out of that? Now, on March 30th, 2012, after expedited discovery, because they want that restraining order, we better get right through discovery, Rule 26F, Civil Rule 26F, says you can't perform discovery until you've had your early resolution conference. And if you have a constitutional issue about statutory interpretation, you're really headed for only one round discovery, if any, because it comes down to statutory interpretation, and it's not heavily reliant upon what you might discover, evidence you want from the other side. It's really based on just the language of the law and an interpretation by a judge to see if, the judge thinks it's unconstitutional, or the judge thinks you have no claim, because it is constitutional. So after expedited discovery, this court held an evidentiary hearing on plaintiff's motion. At the hearing, 3 plaintiffs testified live, and pursuant to stipulation, another by sworn declaration. They were probably out of the state. They weren't in the same location. They were far removed from where the litigation was filed, and so they testified by declaration. The government did not call any witnesses, submit any documentary evidence, or file any declarations in connection with its proposition or opposition to plaintiff's motion. The parties filed post-hearing memoranda, and the motion was fully submitted May 4th, 2012. So they're given a procedural background to introduce you to the case. As mentioned, plaintiff's challenge of 1021 as vague and thus violative of their First and Fifth Amendment rights. The government opposes plaintiff's request for preliminary injunctive relief on 3 bases. Listen to this closely. First, the plaintiffs lack standing. Second, even if they have standing, they have failed to demonstrate an imminent threat requiring preliminary relief. And finally, through a series of arguments that counter plaintiffs' substantive constitutional challenges, that Section 1021 of the NDAA is simply an affirmation or reaffirmation of the authority conferred by the 2001 authorization for use of military force. So first, the plaintiffs lack standing. They're talking about Article 3 standing. There has to be a real controversy, either actual damages or an imminent threat that damages will happen or occur or be incurred by the parties that are suing. Second, that even if there is an imminent controversy, they have failed to demonstrate an imminent threat, meaning there's no reason to read this law as one that impacts your First Amendment activities. And finally, through a series of arguments that counter plaintiffs' substantial constitutional challenges, that 1021 of the NDAA is simply an affirmation of pre-existing authority. It doesn't add anything new. This is what the government is telling the court. Please don't issue the injunction. You're wasting your time. They haven't proven an imminent threat, and that it's only a reaffirmation of existing authority. And so they haven't stated a claim. It doesn't threaten their activities. That's what the government is claiming. In essence, the government argues that an affirmation of the UMF, the authorization of use of military force, Section 1021 of the NDAA does nothing new. And therefore, since the type of activities in which plaintiffs are engaged were not subject to legal action under the UMF, there is no reasonable basis for plaintiffs to assert that 1021 could suddenly subject them to government action now. Meaning, the government action before didn't threaten their First Amendment activities, and since this does nothing but reaffirm that existing authority, it can't be read as an act that will affect their conduct now. According to the government, as an affirmation of the UMF, the NDAA must be read against the backdrop of executive practice and court decisions, a backdrop which clarifies the scope of 1021. Excuse me. And here's the district court's holding. This court finds that plaintiffs who, as discussed below, have a reasonable fear of future government action sufficient to confer standing, they have carried their burden with respect to the necessary elements for issuance of a preliminary injunctive relief. They have demonstrated a likelihood of success on the merits with respect to their constitutional challenges. They have put forward special evidence of actual and threatened irreparable harm. The balance of the equities and the public interest favors issuance of the preliminary relief, particularly but not only in light of the fact that the government's entire position is premised on the assertion that 1021 does nothing new, that it simply reaffirms the UMF. authorization of use of military force. In which case, preliminary enjoining enforcement should not remove any enforcement tools from those the government currently assumes are within its arsenal. Accordingly, this court preliminarily enjoins enforcement of 1021 pending further proceedings in this court or remedial action by Congress mooting the need for such further proceedings. The court didn't say, unless you win on appeal. The court is so sure that this infringes on First Amendment rights, rights to free association and rights to free speech, rights to protest the government, rights to petition for redress. Accordingly, this court enjoins enforcement pending further proceedings in this court. Well, the proceedings in this court ended with the preservation of the preliminary injunction. I'm going to tell the U.S. government, because I'm a U.S. judge, that it can't enforce the National Defense Authorizations Act against these people. Here's a restraining order against the defendants, Barack Hussein Obama and others. So that was the background. I'm sorry, that was the holding. Here's the background, and you can read this at your leisure. On the first page, you have the docket number. You can look that up. This document was on the web, downloaded right off of Pacer, the court's database. And here's the procedural background. Here's what everybody has claimed. Here's the background on the UMF, the authorization of use of military force. It provides this. It provides that. And here are the cases that have interpreted it regarding the Taliban and other groups. And so they get into a history of how the UMF has been enforced, what it means, what people have said about it. And here's section 1021 on page 7 of the court order. And here's the government's representation of section 1021. The government's representation regarding 1021. The government did not call any witnesses at the hearing on this motion. They don't need to. It's about statutory interpretation. There's no witness they could bring in unless, they got their own experts. They are experts, presumably, Department of Justice attorneys. They did, however, submit briefing in advance of and subsequent to the hearing. Cross-examination plaintiffs at the hearing. They cross-examined the plaintiffs at the hearing and made legal arguments at the hearing. As stated above, the government's main contention is that 1021 is merely an affirmation of the authority given the president in 2001 under the UMF. And it goes no further and it does nothing more. That's the government's argument. This doesn't even apply. It doesn't threaten any of their activities. It simply says what the government's authority was in 2001. And so there's no big deal. The government's argument is that these people are safe from what they say is imminent harm. It won't exist. It won't happen because this is just a restatement of existing authority, and existing authority did not do this that they claim this law does. So already the government is trying to get the court away from the argument, telling the court it's irrelevant. They don't have a claim. It doesn't add anything new to the law. Here's the discussion. And I'm on page 35 of this 68-page order. 68 pages. You want to be a judge? This is what judges do. I'd hate to be a judge and have to write all this stuff all the time. This is what judges do. And it's respectable when they do it correctly. But when they capsulate your argument and just stand back and throw stones at it, frivolous, without merit, tax protester, get the hell out of my court type of thing that they do with Tax Code Section 83 At the same time, all the circuits and tax court and the IRS says 83 explains how to tax your paycheck. Section 83 of the tax code. Well, we aren't going to talk about it. That's when judges are not doing their jobs. And there are 5 key statutes in the tax code that you know from my other seminars here on Take from Caesar that they run from. So this is when a judge does her job. She may have been incorrect, as we'll see on the Second Circuit decision, but for what it's worth, she felt compelled to write a 68-page memorandum opinion and order about whether or not she's going to grant this injunctive relief. Discussion. Plaintiff's challenge to the constitutionality of 1021 and request for preliminary injunctive relief requires this court to answer the following questions. Do these plaintiffs have the standing to bring this action? That's Article 3 standing, Article 3 of the Constitution. There has to be an actual controversy and imminent harm, or harm already done. The plaintiffs have to articulate reasonable explanations as to how the harm done relates to the defendants. And number 3, they have to show that if the court got involved, the court could resolve the controversy. Those are that's the three-prong test, of Article 3 standing. Next, if plaintiffs do have standing, or at least some of them do, are they able to meet the demanding standards for preliminary injunctive relief? As set forth below, the court answers those questions in the affirmative, meaning we feel there has been harm or there is harm that's imminent. It comes from the defendant's enforcement of the NDAA, and if the court gets involved, the court can resolve the controversy, and the court finds affirmatively that they are qualified, they have made a good enough argument to impress the court with their request. The court believes they should get an injunctive preliminary injunction or a restraining order. Article 3, standing. Article 3, Section 2 of the U.S. Constitution empowers this court only to entertain actual cases and controversies. Standing doctrine determines whether the plaintiff has made out a case or controversy between himself and the defendant within the meaning of Article 3 and is therefore entitled to have the court decide the merits of the dispute or of particular issues. A citizen who dislikes a particular law may not require a court to address its constitutionality simply by stating in a complaint his belief, however deeply held, that the law is inconsistent with a provision of the Constitution. Concrete injury is required, or imminent injury. And later, she gets into public interest. There's a strong public interest in protecting rights guaranteed by the First Amendment. Quoting this case, the constitutional guarantee of free speech serves significant societal interests. By protecting those who wish to enter the marketplace of ideas from government attack, the First Amendment protects the public's interest in receiving information. There is also a strong public interest in ensuring that due process rights guaranteed by the Fifth Amendment are protected by ensuring that ordinary citizens are able to understand the scope of conduct that could subject them to infinite military detention. Yes. Weighed against these public interests is the strong public interest in upholding acts of Congress and thereby maintaining the appropriate separation of powers. There is also a clear public interest which counsels for cautious use of judicial power to enjoin an act of Congress, and the public interest in ensuring protection from terroristic acts and that law enforcement has the tools necessary to be as effective as possible in that regard. The government has assisted the court in its deliberations with respect to the risks associated with the various interests on each side of the ledger. In light of the government's contention that 1021 does nothing new, that it goes no further than the oomph, the court can only assume that the government believes that preliminarily enjoining enforcement of 1021 will not expose the public to any increased risk, and that 1021 does not add anything to law enforcement's tools. This court is acutely aware that preliminarily enjoining an act of Congress must be done with great caution. However, it is the responsibility of our judicial system to protect the public from acts of Congress which infringe upon constitutional rights. As set forth above, this court has found that plaintiffs have shown a likelihood of success on the merits regarding their constitutional claim, and it therefore has a responsibility to ensure that the public's constitutional rights are protected. Accordingly, this court finds that public interest is best served by the issuance of the preliminary relief recited herein. And the conclusion, we're at page 68. For the aforementioned reasons, plaintiff's motion for preliminary injunction is granted. Enforcement of 1021 of the NDAA is preliminarily enjoined pending further order of this court or amendments to the statute rendering this opinion and order moot. The clerk of the court is directed to terminate the motion for preliminary injunction and the motion to file amicus brief at docket numbers 3 and 31. Catherine B. Forrest. So the court has said, the government has argued that it adds nothing new, but in the interest of the First Amendment, I'm going to issue the restraining order. How about that? The plaintiffs got what they wanted against the big bad government of the United States, despite the arguments of the Department of Justice that says we don't have that authority that they claim we do. Very rare instance. They always claim they have way more authority than what the law reads. Trust me. And here we have them saying, we don't have that authority. We got the same old authority from 2001. What are they complaining about? Don't issue the injunction. It doesn't apply to them. And since it doesn't apply to them, they don't have standing. Here is the Second Circuit's opinion, which says we're going to can the restraining order, and everybody goes, don't do that. Then they can arrest us and we'll be in prison the rest of our lives. Don't lift the restraining order. Oh no. And yet we have pandaunite.org, P-A-N-D-A. He didn't want to say P-A-N-D-A-A, People Against National Defense Authorizations Act, so he chopped an A off of it. Pandaunite.org has chapters across the United States to halt the enforcement of the NDAA on U.S. soil. Chapter in every state. Help us. Join our organization. We're trying to get a chapter in every state. A young guy that says, you don't need an education, you need activism. Nobody ever got anything with their education. You need to be out in the streets. And so we're getting a chapter in every state, and we're educating people. Well, excuse me, I thought you said you did this without education. So we're supposed to follow you when you admit to having no education so that you can educate us without an education? Really? Really? That's something else. This is from WorldNet Daily in an article by Bob Unruh, U-N-R-U-H. This is in an article about the NDAA. We're all going to die in FEMA camps. The firm of William J. Olson, and here's the address right here. You can type that in and read the article yourself. The firm of William J. Olson, which filed a friend of the court brief asking the court to step in, noted that not a single justice dissented from the denial of the request for review. Because when the Second Circuit said we're going to lift this restraining order, then Hedges and the other journalists and activists appealed to the Supreme Court, and the Supreme Court said we don't have to hear this, meaning the Second Circuit, dropping the preliminary injunction, did the right thing. And everybody said, how can you do this? You've hung us out to dry. You lifted the injunction. We're all going to die in a FEMA camp. And this is an article about the Supreme Court having declined to hear the controversy and reinstate the injunction. The Supreme Court just said, everything's fine, meaning what the Second Circuit said is fine with us. Not a single justice dissented from the denial of the request for review. The court ducked, having no appetite to confront both political parties in order to protect the citizens from military detention, the legal team said in a statement to WorldNet Daily. The government has won, creating a tragic moment for the people and what will someday be viewed as an embarrassment for the court. That's a legal team saying that. Oh, okay. WorldNet Daily reported when the indefinite detention provisions of the National Defense Authorizations Act were adopted and later challenged in court. The controversial provisions authorized the military, under presidential authority, to arrest, kidnap, detain without trial, and hold indefinitely American citizens thought to represent an enduring security threat to the United States within the 50 states. That's where these people were when they filed this lawsuit. They were a couple of them were non-resident alien or resident aliens, but the others were citizens of the United States in the 50 states. And the Second Circuit said, well, no, we're going to lift that injunction. Oh, no, we're all going to die in FEMA camps. And this is right out of the article at this website, WorldNet Daily. And then we have the Rutherford Institute. John Whitehead, or Whiteheads. John Whitehead, he's an accomplished civil rights attorney, as I read it. And he wrote a book about how the Supreme Court is proceeding in lockstep with the police state. And this is his comment about a chapter in his book about the NDAA. And he writes on his website, here's the address, the military can arrest and detain American citizens. In refusing to hear Hedges versus Obama, a legal challenge to the indefinite detention provision of the National Defense Authorizations Act of 2012, the Supreme Court affirmed that the President and the U.S. military can arrest and indefinitely detain individuals, including American citizens. In so doing, the High Court also passed up an opportunity to overturn its 1945 Korematsu versus U.S. ruling allowing for the detention of Japanese Americans in concentration camps. Oh no. And this address is the granddaddy. There's a bunch of articles on InfoWars, which is Alex Jones. And his people, his reporters, all the time refer to the NDAA as authorization to scoop up Americans in any of the 50 states and detain them indefinitely without habeas corpus. So you find a bunch of comments from the Alex Jones staff, as well as Alex Jones himself, that we're all going to die in FEMA camps. They can arrest and detain anybody that raises their voice against the government. And so the Second Circuit rules, and this is the Second Circuit decision that says, oh no, we don't need a restraining order. These people don't have standing. And everybody failed to read this. And they just flew off the handle behind one another, one lemming following the other lemming off the cliff of ignorance. Enrollment in the ignorance of the law school because they can't read. It's fun to be able to sit back and say this. It's tragic to have to say it. Here are how many Americans? Countless Americans that simply don't get it. They have missed the boat. Now, I'm going to remind you right here. The talk shoe episode right here at this address on the web, type that in, you'll come to an archive page. Go to this episode. In this episode, I have a recording of the youngster that established pandaunite.org. He was on John B. Wells' show called Caravan to Midnight and interviewed by John B. Wells, who, in his own ignorance, is impressed by this youngster So if you want to hear what pandaunite.org has to say about the NDAA, you can simply look up this episode, because I did a radio program episode about this particular set of decisions. Okay? Now back to the Second Circuit. I showed you that many people are of the opinion that, yeah, we're all going to FEMA camps, and they'll kill us in there. We'll die of old age in these FEMA camps. And yet, the Supreme Court gets the appeal and says, no, everything's fine. What the Second Circuit said was just fine. And so everybody sets up websites and an organization, and they set about making sure that we got to stand against the enforcement of this. The Supreme Court blew it. They sold us out. And yet, as we read this decision, you'll see proof that nobody else even bothered to read this decision. And so once again, I'm taking exception to willful ignorance. There's no excuse for people to have failed to read this decision. It gives them everything they want against the National Defense Authorizations Act in a form other than an order saying, don't enforce this law, it's unconstitutional. What if the law didn't apply to you? That's what the Second Circuit decided. Since the law doesn't even apply to you, because you're a citizen within the 50 states, you don't have standing to bring an action because there's no case in controversy. This law won't apply to you. What are you doing here? That's what the Second Circuit decided. Now, it really is that easy, and I'm taking you through this slowly so that it'll be easily capsulated in your brain, that at the end of this, there won't be questions to answer. You're going to see that people were out of their minds or out of school when they decided that the Supreme Court sold them out. They didn't bother to read the decision. Here's what the Second Circuit held. I'm on page 2 of a 60-page decision. Here's the holding. Defendants, appellants, seek review of a district court decision. That's the government. The government wants review of a district court decision permanently enjoining enforcement of Section 1021 of the National Defense Authorizations Act on the ground that it violates First and Fifth Amendments. We conclude that Section 1021 has no bearing on the government's authority to detain the American citizen plaintiffs, and that those plaintiffs therefore lack standing. Defendant appellants, that's the government, they were sued, they're the defendants, they appeal. They seek review of a district court decision permanently enjoining enforcement of the NDAA on the ground that it violates First and Fifth Amendments. The preliminary injunction was based on perception by the district court that it violates the First and Fifth Amendments. But the defendants, the government, is appealing. We conclude, we're the Second Circuit Court of Appeals, we conclude that Section 1021 has no bearing on the government's authority to detain the American citizen plaintiffs. And therefore, those plaintiffs lack Article 3 standing. There is no controversy. This law can't apply to them. Moreover, the non-citizen plaintiffs, those are the resident aliens I told you about, people from other countries here to join in this lawsuit, the non-citizen plaintiffs have failed to establish sufficient basis to fear detention under the statute to give them standing to seek pre-enforcement review. So nobody is even properly before the court. You weren't properly before U.S. District Court. And since you weren't properly before the court, we have to vacate the court's preliminary injunction because you didn't have what it takes to appear before the court. Vacated and remanded. we vacate the preliminary injunction and send it back to U.S. District Court for a decision in conjunction or in compliance with the terms of this memorandum. Okay? And here you got a list of plenty of attorneys, some for the government and a whole bunch for the plaintiffs to say, we're all going to die in FEMA camps. Please keep the injunction in place. These are all people that believe they should have received an injunction even when the government said in district court, what are you doing here? This adds no new authority to anybody's permission under the law that previously existed as of 2001 with the UMF, the authorization for the use of military force. And here the government is taking it to them, and the Second Circuit agrees. On September 11, 2001, Al-Qaeda and a bunch of other groups attacked us, which empowered President Bush to use all necessary and appropriate force against those nations, organizations, and persons responsible for the attacks, and those who harbored such organizations or persons. Nearly 12 years later, the hostilities continue. Presidents Bush and Obama have asserted the right to place certain individuals in military detention without trial in furtherance of their authorized use of force. Substantial litigation has ensued over the scope of presidential military detention authority. That is, whom did Congress authorize the president to detain when it passed the authorization for use of military force 2001? This controversy over Section 1021 was immediate. As soon as they passed the National Defense Authorizations Act, bingo, people sued. The government contends that Section 1021 simply affirms authority that the government already had under the UMF, suggesting at times that the statute does next to nothing at all. Plaintiffs take a very different view. They are journalists and activists who allegedly fear that the government may construe their work as having substantially supported Al-Qaeda, the Taliban, or associated forces. They contend that 1021 is a dramatic expansion of the president's military detention authority, supposedly authorizing the military, for the first time, to detain American citizens on American soil. As one group of that's a friend of the court, has noted, rarely has a short statute been subject to more radically different interpretations than 1021. So they contend that it's a dramatic expansion of the military authority for the first time to detain American citizens. They say for the first time. That means they say it's in addition to 2011 and the authorization for use of military force, the UMF Act, right up here. They say for the first time, meaning it was new authority that wasn't there in 2001 when the first act was passed. Plaintiffs brought this action shortly after the statute was enacted. They sought an injunction barring enforcement of 1021 and a declaration that it violates, among other things, their rights under the First and Fifth Amendments to the U.S. Constitution. The district court agreed and entered a permanent injunction restraining detention pursuant to Section 1021. It is that decision that we review here. We conclude that plaintiffs lack standing to seek pre-enforcement review of Section 1021 and vacate the permanent injunction. That's what everybody was up in arms about, is that, oh no, you have to keep this in place. And they appealed to the Supreme Court. And the Supreme Court said, everything's fine. So the Supreme Court backed up this paragraph by not hearing the case. We conclude that plaintiffs lack standing to seek pre-enforcement review of Section 1021 and vacate the permanent injunction. The American citizen plaintiffs lack standing because 1021 says nothing at all about the president's authority to detain American citizens. And while Section 1021 does have a real bearing on those who are neither citizens nor lawful resident aliens and who are apprehended abroad, the non-citizen plaintiffs also have failed to establish standing because they have not shown a sufficient threat that the government will detain them under 1021. Accordingly, we do not address the merits of plaintiffs' constitutional claims. They vacated the lower court's decision without deciding on the merits. But the reasons for deciding that they should vacate the lower court's decision is a decision on the merits without explaining the merits. It's a case in the mirror. We do not address the merits of the case, but the reason they vacated the lower court's decision is a decision on the merits. That's what confused everybody. Right there. Right there in plain sight. We do not address the merits of the plaintiff's constitutional claims. Hey, this statute violates my First Amendment rights because I can't associate or freely speak. I'm an activist. I'm a journalist. And it violates my rights to Fifth Amendment because I can be held indefinitely without habeas corpus. Oh, you're right. Let me issue the preliminary injunction. Here's a permanent injunction against the government. The government appeals, and the court says, we aren't even going to address the merits, which is why they got the injunction in the lower court, because the lower court said, you know, the merits are pretty strong. It looks like it would violate your First and Fifth Amendment rights. Here's your injunction. And here they say, we aren't even going to decide the merits. These people don't have standing. Why? Because of the merits. They don't have standing. The law doesn't even apply to you. Well, if that isn't a decision on the merits, I don't know what is. But they based it on standing and a lack thereof. And it confused the hell out of everybody. And so you got the entire country out there going, we're all going to die in FEMA camps if we raise our voice against the government. Help us, help us. And the Supreme Court sold us out. This is where the confusion, this is the point from which the confusion has arisen. Is we're not going to address this based on the merits. You don't have standing to sue. And so you weren't even properly before the court. Everything in the lower court is hereby vacated. Well, why didn't we have standing? Because this law doesn't even apply to you. Well, that pretty much solves the problem, doesn't it? If the law doesn't even apply to you, what are you worried about it being enforced against you? And that's what drives you to the very underlying basis for my particular approach to this is that if the government can't handle you with the law, they'll handle you without the law. They don't need the National Defense Authorizations Act. They'll simply take you and hold you on diesel therapy. You know what that is? Where they shuttle you from prison to prison to prison so you can't get your mail within 60 days of when it was sent to you, and you're held in the SHU, the Special Housing Unit, SHU, where it's you in solitary or maybe with one cellmate. You get one 15-minute phone call every 30 days. You get maybe an hour in the law library every day. It's on computer, and you don't have copy privileges, so you can't print off the authorities that you rely upon. You can't do any typing or store a document. And that's how they hold you indefinitely, is shuttle you from prison to prison to prison, so that while your case is working its way through the courts with utterly ineffective and uneducated public defenders, you sit on your ass in a federal prison. They don't need the law. But rising above that, in a fantasy world where the law actually means something, this court says the law doesn't even apply to you. It can't be used against you. Oh, well, we better get an organization in all 50 states and come out and protest against the enforcement of this law. Why can't they read this? It doesn't apply to you. You don't have standing. Well, we're going to protest it anyway. Okay. Well, that's a lot of energy and a lot of resources that would have been better devoted to some other cause, don't you think? Like the health care bill? Something else. Introduction. On September 11th, the Al-Qaeda attacked the buildings, killed 3,000 people. and they got the enforcement authority under the UMF to use force against those nations, organizations, and other persons responsible. Nearly 12 years later, this reads a lot like the district court. And so, whom did Congress authorize the president to detain when it passed? Okay. Proceedings below. Plaintiff Christopher Hedges filed an initial complaint with this case in January 2012, alleging that 1021 violated the First and Fifth Amendments and seeking a declaratory and injunctive relief, which they got in the lower court. On February 27, 2012, he filed a verified amended complaint, which added a number of plaintiffs and moved for a temporary restraining order. The motion that later was converted to a motion for preliminary injunction. Plaintiffs submitted a number of affidavits in support of their motion, and the district court held an evidentiary hearing in March of 2012. The district court granted a preliminary injunction. It concluded that each plaintiff had an actual fear of detention under 1021 and that this fear was reasonable. In reaching this latter conclusion, the court relied on, in significant part, on the government's initial refusal to represent that the plaintiff's activities would not subject them to detention under 1021. Let's read that again. In reaching this latter conclusion, that the fear was reasonable, the court relied in significant part on the government's initial refusal to represent that the plaintiff's activities would not subject them to detention under 1021. It rejected the government's contention that 1021 was just an affirmation of the UMF and did nothing new. Determining further that the expressive conduct of each plaintiff had been chilled and that each had incurred concrete costs as a reasonable consequence of this fear, the court concluded that each plaintiff had standing to challenge Section 1021. It held that plaintiffs had shown a likelihood of success on claims that 1021 violated the First Amendment and was impermissibly vague in violation of the Fifth Amendment. Finally, it concluded that the other relevant factors supported preliminary injunctive relief. So, void for vagueness, I misspoke. It's not the apprehension about being held without habeas corpus. It's actually a claim that the law was vague, Fifth Amendment, and that it infringed free speech, First Amendment. And the discussion. The parties raise a number of important and difficult questions, but we need not reach most of them. Why? Because they didn't have standing before the court. Why? Because the law didn't apply to them. So didn't they get everything they wanted out of the Second Circuit decision? It doesn't even apply to you. Why do you need an injunction? Once again, the parties raise a number of important, difficult questions, but we need not reach most of them. We consider here only plaintiffs standing under Article 3 of the Constitution. We begin with a brief discussion of the principles of Article 3 standing. We proceed to the proper construction of 1021 in relation to the authorization for use of military force. After clarifying that Congress did and did not, what Congress did and did not do in passing 1021, we consider plaintiffs standing given the record in this case. In that regard, we address first the American citizens, Hedges and Obama, and then the non-citizens. You can pronounce those last names in your spare time. And so they get into it. And once again, this document is right out of the court's database. So you can look this document up. As with any question of statutory interpretation, we begin by examining the text of the statute. In doing so, we consider not only the bare meaning of the critical word or phrase, but also its placement and purpose in the statutory scheme. It is one of the most basic interpretive canons that a statute should be construed so that effect is given to all of its provisions, so that no part will be inoperative or superfluous, void or insignificant. But in interpreting a statute, a court should always turn first to one cardinal canon before all others, namely, that courts must presume that a legislature says in a statute what it means, and means in a statute what it says there. When the words of a statute are unambiguous, then the first canon is also the last. Judicial inquiry is complete. If the language of the statute is clear, we don't need to ask any more questions because Congress writes the laws. It meant what it says. So if it's clear, great. Our inquiry regarding clarity is done. Then we have to move to whether or not it's constitutional. Okay? Makes perfect sense, and you'll find that standard articulated in literally hundreds of Supreme Court cases, thousands of Supreme Court and appellate court cases. It's everywhere. It remains to consider what effect Section 1021 has on this understanding. That provision states that nothing, this is right out of 1021. The argument over all of this is about Section 1021. We're all going to FEMA camps. And in 1021E, it says right there, nothing in this section shall be construed to affect existing law or authorities relating to the detention of United States citizens, lawful resident aliens, or any other persons who are captured or arrested in the United States. I can't read, and so I'm going to file a lawsuit against the president and a bunch of other people and get a restraining order because I can't read this. It's right in the law. This adds nothing to the law. And if it adds nothing, then the authority for detention in perpetuity has to be in the 2001 Act, doesn't it? And they weren't even challenging that. Something else. Although this provision may appear superficially similar to 1021D, nuances in the language and legislative history make clear that 1021E actually is a significantly different provision. As discussed above, in stating that 1021 is not intended to limit or expand the scope of the detention authority under the oomph of 2001, Section 1021D mostly made a statement about the original authorization to use of military force. That is, it indicated that the specific power to detain those who were a part of or who substantially supported the enumerated forces had been implicit in the more generally phrased authorization to use of military force. By contrast, in saying that Section 1021 shall not be construed to affect existing law or authorities relating to citizens, lawful residents, or other persons captured or arrested in the United States, Section 1021E expressly disclaims any statement about existing authority. Rather, it states only a limitation about how 1021 may be construed to affect that existing authority, whatever that existing authority may be, may already be. It did nothing to existing authority. But I can't read, so I'm going to file a lawsuit. It's something else. Rather, Section 1021 provides that Section 1021 just does not speak one way or the other to the government's authority to detain citizens, lawful resident aliens, or any other persons captured or arrested in the United States. That's something else. And here, key point. Don't forget this. It does not add, it doesn't even speak to detention authority. It simply says nothing in this act broadens any authority that didn't already exist. We thus conclude, consistent with the text and buttressed in part by the legislative history, that 1021 means this: with respect to individuals who are not citizens, who are not lawful resident aliens, and are not captured or arrested within the United States, the President's authorization to use of military force authority includes the authority to detain those responsible for 9/11, as well as those who were part of or substantially supported Al-Qaeda, Taliban, or associated forces that are engaged in hostilities against the United States or its coalition partners. A detention authority that 1021 concludes was granted by the original authorization to use of military force. But with respect to citizens, lawful resident aliens, or individuals captured or arrested in the United States, 1021 says nothing at all. But we got lawyers, we got all kinds of people that say otherwise. Well, this is the Second Circuit, and the Supreme Court affirmed this. We have to go by this. And so you were wrong. Alex Jones, pandaunite.org, John Whitehead at the Rutherford Institute, whatever. And so you're wrong. Well, what are we going to do? You're going to sit there and cry like a baby because you didn't read the decision. American citizen plaintiffs. With this understanding of 1021, we may dispose of the claims of the citizen plaintiffs, Hedges and O'Brien. As discussed above, 1021 says nothing at all about the authority of the government to detain citizens. There simply is no threat whatsoever that they could be detained pursuant to that section. While it is true that 1021E does not foreclose the possibility that previously existing law may permit the detention of American citizens in some circumstances, a possibility that Hamdi clearly envisioned in any event, he was one of the other plaintiffs, Section 1021 cannot itself be challenged as unconstitutional by citizens on the grounds advanced by plaintiffs because as to them, it neither adds nor subtracts from whatever authority would have existed in its absence. For similar reasons, plaintiffs cannot show that any detention Hedges or O'Brien may fear would be redressable by the relief they seek, an injunction of 1021. Plaintiffs appear to contend that even if Section 1021 is not applicable to Hedges and O'Brien, the wording of 1021E seems to assume, and that's where we get to the void for vagueness argument, seems to assume that citizens may be detained if they have substantially supported Al-Qaeda, and the Hedges and O'Brien therefore have standing to challenge it. We disagree. There is nothing in 1021 that makes any assumptions about the government's authority to detain citizens under the OMF. Rather, 1021E quite specifically makes clear that the section should not be construed to affect, in any way, existing law or authorities relating to citizen detention, whatever those authorities may provide. And the conclusion. We're on page 59 of 60. Section 1021 is concerned entirely with the military authority of the President with respect to non-citizens abroad, a context in which Congress provides the President broad authority to exercise with considerable discretion, like drone strikes. Particularly after the Clapper decision, plaintiffs must show more than they fall within the ambit of this authority to establish the sufficient threat of enforcement necessary for Article 3 standing. They have failed to do so here. Picture the person that's the subject of the drone strike. You never really even learn about that so you could challenge their action. If you're a foreign fighter and you're going to be hit with a drone strike, there's no such thing as notice and opportunity to defend. Simon versus Kraft. A final note. Plaintiffs repeatedly refer to the First Amendment overbreadth doctrine as if it were relevant to whether they have established Article 3 standing. It is not. Relaxing the general prudential rule, that means court-created rule, against third-party standing, the overbreadth doctrine permits a plaintiff to represent the legal interests of parties not before the court when seeking facial invalidation of a statute under the First Amendment if certain conditions are met. Critically, we allow a party to bring an overbreadth challenge where the party satisfies the Article 3 requirement of injury in fact, and where it can be expected satisfactorily to frame the issues in the case. In other words, the overbreadth doctrine speaks to whose interests a plaintiff suffering Article 3 injury may represent. It does not provide a reason to find such inquiry where none is present or imminently threatened in the first instance. So that was a discussion, briefly however, of the right to litigate claims that might affect a third party. In sum, Hedges and O'Brien, the citizen plaintiffs in the 50 states, in sum, Hedges and O'Brien do not have Article 3 standing to challenge the statute because Section 1021 simply says nothing about the government's authority to detain citizens. While Section 21 does have meaningful effect regarding the authority to detain individuals who are not citizens or lawful resident aliens and are apprehended abroad, these two have not established standing on this record. We vacate the permanent injunction and remand for further proceedings consistent with this opinion. And the Supreme Court said, right, we don't need to hear this case. Next case, please. And everybody goes, oh, the Supreme Court let us down. They sold us out. It's in lockstep with the police state. I'm John Whitehead of the Rutherford Institute. And oh, this is terrible. I'm an attorney. And you have website after article after website after article. We're all going to die in FEMA camps. When the Second Circuit said this law doesn't even apply to citizens or resident aliens living inside the United States. What are we to conclude? A, nobody can read. They're illiterate victims of public school. They can't read. Or, number two, they're incompetent. They didn't even bother to read this decision. Or three, they read this decision and they're not incompetent. They simply lack all sense of reason. They can't reason. They have no capacity for critical thought. They can't read in another sense other than being illiterate. They're legally illiterate. They're functionally illiterate when it comes to law. Because here it is, right here. And once again, this talk show episode, let me go find that again for you. Right here, talk show, November 19th, 2014, a year and a half ago. It's July 4th, 2016. I went through all this in radio. It's just audio, so I always wanted to do a video presentation like this for it. I'm just now getting around to it, but it's the same lesson plan, the same conclusions, and the same assessment of the capacities of the people to go, we're all going to die in FEMA camps, help us. Warning, warning, we're all going to die in FEMA camps. You got to spare me. The Supreme Court, by refusing to hear the Second Circuit argument, or the Second Circuit case, when it was appealed by the plaintiffs, the activists and journalists, by declining to decide the case, they ratified what the Second Circuit said. And the Second Circuit said 1021 doesn't even discuss the authority of the president to detain citizens and resident aliens in the 50 states. And everybody said, well, we got to prevent enforcement of this. And you'll hear Alex Jones and his staff all the time, and we got the National Defense Authorizations Act, and they'll just haul you off to a FEMA camp. So for one of those three reasons, they're functionally, they're illiterate. They can't read writing. Or number two, they're incompetent. Or number three, they're legally illiterate. They're members, proud graduates of the ignorance of the law school, because there's no excuse for this. You got all their listeners and all their readers worked up in a froth about, oh, we can't go against the government. So they're doing the government's work for them. They're out there with their misunderstanding, intimidating everybody from raising their voices. Through a misunderstanding of the law. Don't raise your voice or you're going to the FEMA camp. You'll be held without habeas corpus indefinitely, in perpetuity. You don't want to be wearing orange the rest of your life. Well, here it is in bold type. You missed it. And yet they're out there doing the government's work for them. Shut up. Don't contradict the government. You're going to the FEMA camp. Anybody that's a troublemaker. When the Supreme Court did the right thing. The law doesn't even apply to you. Well, we're going to start an organization. We're going to write articles. We're going to have a piece on this on Alex Jones InfoWars. Tune in and watch the video for this Friday, because we're going to go over the NDAA, National Defense Authorizations Act, what you can expect if you're locked up in a FEMA camp. And everybody trembles. Oh, they must know what they're doing. They got a website. They got a broadcast. And they're wrong. So once again, ignorance strikes a blow against freedom. So I hope you've enjoyed this video presentation. Again, none of this is legal advice. My name is David Merlin. This is my take on it. And if anybody wants to contradict me, come up with a decision that says something else. But I hereby accuse everybody that has come out in favor of protests about the Supreme Court's decision to not weigh the merits of this Second Circuit opinion. I hereby accuse you of incompetence. You don't know what you're doing. You really lack a clue when it's this easy for me to just look slowly at the decision and say, what in fact did the Supreme Court ratify when it said we're not going to hear Hedges versus Obama? They ratified a decision that says, excuse me, but this law doesn't even apply to you. What's the problem here? You aren't properly before the court. You can't suffer an injury. And so you have no Article 3 standing. Next case, please. And it's not good enough for everybody else. Thank you for visiting me on Take from Caesar. I urge you to take in the other tutorials and seminars here on my YouTube channel, and to visit wevgov.com, wevgov.com, W-E-V-G-O-V. And there's a written version of a couple of key arguments on the federal income taxation page. The solution to the motor vehicle code, the question everybody's always had about what happened to my right to travel, it seems to have evaporated. No, it's just misenforcement of the motor vehicle code. It's never been written to apply to travelers. And so you have to do a historical workup on the scope of your motor vehicle code in your state, and you're going to find it was never broadened beyond its original intent. It only applies to those who use the streets as a place of business. And state income taxes. They've all adopted the federal income tax code as state law, as you'll see on that state income tax page. And under the federal income tax law, you'll see that they're violating state law as well to tax you on compensation for services on the state level. So there's so much at wevgov.com, I can't tell you. IRS. This is something you shouldn't forget. IRS, Internal Revenue Service. IRS, illegal revenue streams. IRS, ignorance reaps slavery. Just learning what I have put on that website, you've identified and proven in writing using legislation alone, you've proven these illegal revenue streams constitute the bulk of government's income. And if government didn't make all that money that it steals from us under those 3 illegal revenue streams, how big would government be? It's magic. When the budget shrinks, government shrinks. And that's why I've limited what I have to say on the website to just the illegal revenue streams. It's an enormous answer to the biggest problems. Big government. If government did not make all that money from us, how big would government be? They'd have to borrow money just to send a patrol car out to you. I'm not saying we need no government, but I'm saying we do need a lot less of it. We got drones over the citizen. What do you want us to do, Captain? We got a police helicopter. We got armored personnel carriers for the local police of a town with 15,000 people. We got M16s. Why? Because the population of this city is 5,000 people. So we need M16s. How do you defeat a mentality like that? You have to do it with a smaller budget. It's the only thing they understand. They want the same thing we want, our money, and they're hell-bent to get it. And here's an example where incompetence and ignorance, you're actually doing the government's job, quelling protest because you say you can go to a FEMA camp when the courts are going, no, you can't. What's wrong with you? There's no controversy here. This law doesn't even apply to you. Next case, please. Anyway, hope you had a great 4th of July, and I'll see you in the next tutorial here on Take from Caesar.